Now let's talk about 4 need-to-know concepts for the NCA constitutional law exam. Purposive approach, ancillary powers, paramountcy, and interjurisdictional immunity. Let's get started. Purposive approach. So the purposive approach is a method used by judges to interpret what statutes or laws mean. And it just means that they need to look at the purpose of the statute and then Parliament or legislators' intention when they created the statute, as well as the words written in the statute itself. So they're looking for context as to what the purpose of the law was supposed to be. Ancillary powers, typically used in reference to the police, where conduct interferes with the liberty of an individual, conduct must be authorized by law. So the Ancillary Powers doctrine permits a police officer to interfere with a person's liberty or privacy during the lawful execution of their duty, as long as the actions satisfy the Waterfield test, which consists of 1, the police are acting in the execution of their duties under common law or statute, and 2, the conduct constitutes a justifiable interference with individual liberty or privacy. This doctrine has never been so expansive as to justify conduct in execution of policing duties. Finally, we have paramountcy versus interjurisdictional immunity. These two things are tied together. So in Canadian constitutional law, paramountcy establishes that where there is a conflict between provincial and federal laws, the federal law will prevail, and the provincial law will be inoperative to the extent that it conflicts with the federal law. Unlike interjurisdictional immunity, which is concerned with the scope of the federal power, paramountcy deals with the way in which that power is exercised. Thank you for watching my video. Please do me a big favor and hit that like button and subscribe to get more videos on law school and NCA exam prep.